I'm Joshua Dorothy. This is an ABA Tips FSLC vlog on liability for fraudulent checks. In the fidelity practice, even though banking and the world in general has become much more digital, check fraud is still a fairly common aspect of the practice. One of the thorniest issues, even for experienced practitioners, is remembering the liability allocation rules within banking law for check fraud. This presentation will provide a primer or a refresher, depending on your level of experience, for how these rules work and where the liability is supposed to fall in most check fraud circumstances. We begin here by looking at the movement of a check through the banking system. Here, our payee on the left side of the slide has received a check from the drawer. The payee is the party who's named in the pay to the order of line of the check. The drawer is the party whose name appears in the upper left corner of the check and whose signature should appear in the lower right-hand corner of the check. The payee takes the check to its bank, referred to as the depository bank or the bank of first deposit, presents the check, and in turn receives money for the check, either over the counter or as a deposit into the customer's account. The depository bank then takes the check to the Federal Reserve or to a clearinghouse, again hands over the check and receives funds. We're assuming here a very simplified system. Some banks have direct relationships with the Federal Reserve, others do not. In that case, you'd see many more banks between the Bank of First Deposit and the Federal Reserve. For simplification purposes, we're just going to assume a direct relationship. So the depository bank presents the check to the Federal Reserve and receives in return a credit to the depository bank's account at the Fed. The Fed then presents the check to the drawee bank, which is the bank identified on the face of the check with its logo and name, either in the lower left-hand corner of the check for most personal checks or in commercial checks near the upper right-hand corner by the check number. The drawee bank receives the check from the Fed and in turn provides funds to the Fed through the form of a deposit, or a debit rather, from its account at the Fed. The drawee bank, now having received the check back, presents the check to the drawer, its customer, and receives funds back, in this case by posting the check to the drawer's account and withdrawing the funds from the drawer's checking account. So now we look at the liabilities and responsibilities at each step of the progress of this check. The liabilities between the payee and the depository bank are twofold. One is funds availability, how soon the bank has to make the deposited funds available to the payee, and the second are the Ucc Transfer Warranties, which are warranties required under the Ucc. The funds availability rules are set under federal regulations, and they're divided between local checks and non-local checks. A check is a local check if the check is drawn on a bank that is physically from the same Federal Reserve check processing region as the depository bank. So this could be a fairly broad physical region, but it's not coast to coast. For a local check, funds have to be made available within 2 business days. In our examples here, we're going to assume that there are no intervening holidays and that none of the events occur on holidays. So if the check is deposited on Monday, the funds have to be made available for withdrawal no later than Wednesday. For a non-local check, this might be a coast-to-coast check. It might be a little bit closer, but still not within the same check processing region. The funds have to be made available within 5 business days. So here, our example, again, the customer deposits the check on Monday. The funds have to be made available for withdrawal no later than the following Monday. The Ucc Transfer Warranties are warranties implied by the Ucc whenever a check moves through the process here. There are 6 clauses within the standard Ucc Transfer Warranty section. The 2 most important are the 2 that have been underlined here. Clause 2 is a warranty that all of the signatures on the check are authentic and authorized, and Clause 3 is a warranty that the check has not been altered. Note that the language that's on the slide here is the uniform law. It is always important to look at how the Ucc has been adopted in the jurisdiction that's at issue. In particular here, Clause 2 is an absolute warranty. This is not limited by knowledge, so the payee is making an absolute warranty that the signatures on the item are authentic and authorized, which may be a fairly broad warranty if the payee has never met the drawer and perhaps received the check in the mail. Now that the check has moved to the Bank of First Deposit, we look at the liabilities and responsibilities between the Bank of First Deposit, the Fed, and the drawee bank. The liabilities and responsibilities here fall into three categories. First is the midnight deadline, which is how soon the drawee bank has to decide to honor or dishonor the check. Next, we have the Ucc Presentment Warranties, and finally the echo warranties, which are made if the check is presented in the form of electronic images through a clearinghouse. The midnight deadline determines when the drawee bank is responsible for the check. A check is finally paid under the Ucc when the drawee first does one of the three actions on the slide here, either paying for the item in cash, making a final settlement that cannot be revoked, or making a provisional settlement and then failing to timely revoke it. The third is by far the most common because what happens here through the Federal Reserve is a series of provisional settlements that become final if they are not timely revoked. The midnight deadline determines when these provisional settlements can be revoked. A provisional settlement can be revoked if the check is returned before the midnight deadline. If the check is not returned by the midnight deadline, then the drawee is accountable for the amount of the check, even if it was not properly payable. All of this makes the midnight deadline critically important and is often one of the first things that a fidelity lawyer should examine when looking at a fraudulent check claim. The midnight deadline is midnight on the banking day following the banking day on which the drawee bank received the check. So for example, if the check arrives at the drawee bank on Monday, then the midnight deadline is midnight at the end of the day on Tuesday. The Ucc provides warranties here that are known as presentment warranties. These are warranties that are made to the drawee bank. The four warranties that are on the slide here are similar but not identical to the transfer warranties. Again, the two most important are in clauses 2 and 3, that the draft has not been altered, and that the warrantor has no knowledge that the signature of the purported drawer is unauthorized. It is notable here that the presentment warranty is qualified by the knowledge of the warrantor. Unlike the transfer warranty, this is not an absolute warranty of an authorized signature. The echo warranties are warranties that are made only with respect to checks that are presented in the form of electronic images that move through a clearinghouse. This warranty is frequently referred to as Rule 9, and so it is common to hear banks refer to this as a Rule 9 claim, even though it now appears in Section 19 of the ECHO rules. The Rule 9 warranty is a warranty made by the Bank of First Deposit directly to the drawee bank that the signature of the drawer is not forged or unauthorized, and that the check itself is not counterfeit. Again, this warranty is not limited by knowledge. There are, however, some unique defenses or disclaimers that are available under the ECHO rules. The first is that the depositing customer's account has been closed. So if the Bank of First Deposit has allowed the customer to close the account after making the deposit of a potentially fraudulent check, the Bank of First Deposit has a defense to a warranty claim from the drawee bank. Second is if the claim amount exceeds the available funds in the depositing customer's account. So if the Bank of First Deposit has allowed the customer to withdraw most or all of the funds from the check, even though the account remains open, the Bank of First Deposit has a defense to the warranty claim under the ECHO rules. Finally, a bank can opt out of the Rule 9. However, this is both a give and a get rule, so if a bank opts out of Rule 9, it cannot make Rule 9 claims. It then can become important when facing a true Rule 9 claim to first look to see if the institutions have opted out here, and ECHO helpfully posts that list on its website. Finally, now that the check has made its way to the drawee bank, we look at the liabilities and responsibilities between the drawee bank and the drawer on whose account this check was drawn. These liabilities and responsibilities address whether the check was properly payable under the Ucc and the customer's liability for reviewing their periodic statements. Under the Ucc, a check is properly payable if it was authorized by the customer and is in accordance with an agreement between the customer and the bank. Note here that signatures don't have to be handwritten, so a check may be valid even if it bears a stamp or a mechanical signature. The bank also is not required to site review every check. So even if a site review would have disclosed that this signature should not appear to be authorized, the bank is not required to have done so. Most important is to look to the account agreement. What does the account agreement between the drawer and the drawee say about whether a check is properly payable? The customer does have some responsibility here to review periodic statements. However, as you'll see, the UCC is fairly permissive to the customer. The customer has to be reasonably prompt and must promptly notify the bank of a problem. The customer must report the first unauthorized signature within 30 days of receiving the statement that discloses the unauthorized signature, and there's an absolute preclusion for a 1-year delay. These are very generous timelines. It is now common for customers to be reporting check fraud before they even get the periodic statement because they're looking at their online account. However, these deadlines that are set forth in the UCC can be shortened, and they frequently are shortened in the account agreement. So it's important to look to the account agreement to see if perhaps the drawer has blown a deadline for reporting check fraud to its bank. Because the deadlines for the drawer to report fraud are so permissive, though, usually the drawer falls out of the scope of parties who may be liable for the check. So we look now to the parties including the payee, the depository bank, the Fed, and the drawee bank. The payee has frequently absconded with the funds and is really no longer available to look at as a source of where the loss should live or the liability should fall, and so the payee falls off of our chart. The Fed, because it lives in this zone of being an intermediary, it's very difficult, if not impossible, to put any liability here onto the Fed, and so the Fed falls out. And what we're really left with then is, as between the two banks on each end of the chain, the Bank of First Deposit and the drawee bank, which bank should bear the loss? And for the most part, we're looking at the presentment warranty. It is important here to note the difference between a return and a warranty claim. A return in the banking law terminology is the dishonoring of a check or the revoking of a provisional settlement before the midnight deadline. This is done through the check presentment system, so the check is simply sent back through the Federal Reserve or through the clearinghouse. This has to be done before the midnight deadline, and the consequence here then is that the chain of provisional settlements is revoked and the funds automatically go back to the drawee bank. A warranty claim, on the other hand, is made after the midnight deadline when it is no longer timely for the drawee bank to revoke the settlement, and now here it is asserting that a prior party has breached one of the warranties. If the presentment was made through the Federal Reserve, then the banks must deal directly. The Federal Reserve does not want to be involved in warranty claims. Banks will sometimes attempt to assert a warranty claim through a return. The Fed will allow a brief ping-ponging of return, late return, no, our return was timely, but will ultimately require that the loss settle somewhere and that the banks deal with each other, and the Fed simply excuses itself from any further involvement. If, on the other hand, the presentment was made through a clearinghouse, then the warranty claim can be made through the clearinghouse, but it does have to be processed as a claim and not as a return, and the clearinghouse rules have a process for doing this. Under the UCC, a warranty claim has to be made within 30 days. The ECHO rules provide 60 calendar days for the drawee bank's customer to report the fraud, and then 15 days from that point for the drawee bank to make the warranty claim back. The consequence of a warranty claim is that the Bank of First Deposit has to repay the drawee bank for the fraudulent check. I hope that this presentation has provided some clarity or refresher for you on how fraudulent checks are allocated within the banking system, and that this can be useful for the next time you have one of these claims in your fidelity practice.